Good morning and welcome to the class. Welcome. We shall begin.
Clerk and Lindsell on Torts 20th ed. Main Volume. Chapter 22, Defamation. Section 6. Defenses. Subsection, C. Qualified Privilege. Subsection, 2. Grounds of Qualified Privilege. Subsection, 2. Media Communications. Media Communications on Matters of Public Interest. The Reynolds Defense. 22 to 135. In Reynolds v. Times Newspapers 672, the House of Lords reviewed the law relating to qualified privilege in respect of publications in the media. The claimant, an Irish politician, sued the defendant newspaper for libel in respect of allegations relating to a political crisis in the Irish Republic and to his resignation from the post of Dowsiak. Granting the claimant a new trial, on the ground of misdirection in the trial judge's summing up, the Court of Appeal considered the defendant's claim that such statements in newspapers, relating to the conduct of individuals in public life, should be covered by qualified privilege. The court accepted that the common welfare of British democracy was best served by ample dissemination to the public of information concerning, and vigorous discussion of matters relating to the public life of the community and to those who participated in it, but concluded that the defendants had not satisfied the tests required. The defendants appealed to the House of Lords, where the law relating to qualified privilege in relation to communications by the media was thoroughly examined. In the words of Lord Stein, important issues regarding the reconciliation of the colliding right of free speech and the right to reputation need to be considered in the light of the new legal landscape. In dismissing the appeal, Lord Stein, Lord Nichols, Lord Cook, and Lord Hobhouse held that there should not be a new category of political information which would invariably attract a generic qualified privilege, but bearing in mind. Page 108. The importance of freedom of expression, such protection might be available to the defendants if in all the circumstances the judge deemed it appropriate. Lord Nichols identified 10 criteria which the court should consider in determining whether the public was entitled to know. 673 Depending on the circumstances, the matters to be taken into account include the following. The comments are illustrative only. 1. The seriousness of the allegation. The more serious the charge, the more the public is misinformed and the individual harmed, if the allegation is not true. 2. The nature of the information, and the extent to which the subject matter is in a matter of public concern. 674. 3. The source of the information. Some informants have no direct knowledge of the events. Some have their own axes to grind, or are being paid for their stories. 675. 4 steps taken to verify the story. See above. 676. 5. The status of the information. The allegation may have already been the subject of an investigation which commands respect. 6. The urgency of the matter. News is often a perishable commodity. 677. 7. Whether comment was sought from the claimant. He may have information others do not possess or have not disclosed. An approach to the claimant will not always be necessary. 678. 8. Whether the article contained the gist of the claimant's side of the story. 9. The tone of the article. A newspaper can raise queries or call for an investigation. It need not adopt allegations as statements of fact. 10. The circumstances of publication, including the timing. The list is not exhaustive. The weight to be given to the various factors will vary from case to case. Any disputes of primary fact will be a matter for the jury, if there is one. The decision on whether, having regard to the admitted or proved facts, the publication was subject to qualified privilege is a matter for the judge. This is the established practice and seems sound. A balancing operation is better carried out by a judge in a reasoned judgment than by a jury. Over time, a valuable corpus of case law will be built up. In general, a newspaper's unwillingness to disclose the identity of its sources should not weigh against it. Further, it should always be remembered that journalists act without the benefit of the clear light of hindsight. Matters which are obvious in retrospect may have been far from clear in the heat of the moment. Above all, the court should have particular regard to the importance of freedom of expression. The press discharges vital functions as a bloodhound as well as a watchdog. The court should be slow to conclude that a publication was not in the public interest and, therefore, the public had no right to know, especially when the information is in the field of political discussion. Any lingering doubts should be resolved in favor of publication. 679. Lord Nichols recognized that the generality of this approach would inevitably give rise to an undesirable element of uncertainty. This was felt to be necessary because page 109. Justice of cases of this nature usually depend on their particular facts and no two cases are the same. 680 As is apparent, Lord Nichols was under the expectation that a body of case law would be built up which would give greater certainty to the law. The House of Lords dismissed the defendant's appeal on the grounds that, although the subject matter of the offending article was of public concern, the allegations in the article, which had contained no mention of the claimant's explanation, were not in the public's interest to know and, upholding the ruling of the Court of Appeal, that the publication was not covered by qualified privilege. The Reynolds decision was revisited by the House of Lords in Jamil v. Wall Street Journal, Europe. 681 The House reiterated that the defense was intended to be applied with considerable flexibility, and criticized the High Court and Court of Appeal for applying the defense too restrictively. The liberalizing effect that was the intention of the Reynolds decision had been subverted by subsequent decisions in the lower courts. The Reynolds standard of responsible journalism needed to be applied in a practical and flexible manner, and Lord Hoffman commented that the case before the House suggested that Reynolds had had little impact on the way the law was being applied at first instance. Development of the Reynolds defense. 22-136. The nature and ambit of the Reynolds defense of qualified privilege has indeed been explored in numerous subsequent cases. From these the following principles have emerged. 1. The form of qualified privilege recognized in Reynolds is different from the traditional common law duty and interest-based privilege. The question of whether the publisher has behaved responsibly is intimately bound up with whether the defense arises. The duty to publish can only arise where the journalist has behaved responsibly. 682. 2. In considering whether a journalist has a duty to publish, the court should not ask whether he would be open to criticism if he did not publish. That is too stringent a test. There will be occasions where one newspaper decides to publish an allegation and another does not. The issue is whether the newspaper that did publish acted reasonably and responsibly in doing so. 683. 3. In determining privilege, the court can only consider the information known to the journalist at the date of publication. Whether a journalist has behaved reasonably and responsibly depends on what information was available when he wrote the article. 684. 4. Where a journalist is neutrally reporting on a matter of genuine public interest, that is a weighty factor in favor of according privilege to the publication. Neutral reporting, or reportage, involves presenting an allegation as an allegation, not adopting it as fact and not taking sides in an ongoing dispute. Where the dispute is on a matter of public interest and the disputants have been attacking each other in public, the other elements in Lord Nichols' 10 principles may be relaxed, e.g. the duty to verify. 685. 5. In contrast, where the newspaper unambiguously asserts that the claimant is guilty of a criminal offense, justification is likely to be the only available defense. 686. 6. Where the publication conveys a more serious defamatory meaning than was intended by the journalist, the defense of qualified privilege may still be available if it was reasonable for the journalist to conclude that the publication, page 110, bore the meaning which he intended it to have. 687. 7. there is no generic privilege for the maintenance of an archive of past press publications, whether electronic or hard copy. If circumstances have changed since the article was originally published, qualified privilege may no longer be available where the newspaper does not modify the version of the article on its website. 688. 8. It is increasingly common for defamation claims to be brought in the English courts in respect of foreign publications with a limited readership in England. In such a case, the issue of reasonable and responsible journalism will be judged by the circumstances and professional standards that apply in the home country of the publication. 689. 9. There is no reason why the Reynolds defense cannot apply to publications made by any person and published in any medium, e.g. slander, provided the conditions of responsible journalism are satisfied. 690. In Flood v. Times Newspapers Ltd 2010 EWCA Civ 804, 2011 1 WLR 153, the Court of Appeal overruled the decision of Tjandat on a preliminary issue regarding whether the Times was entitled to rely on the Reynolds qualified privilege defense in relation to an article concerning the claimant. The first instance decision had been the first case in which a national newspaper had successfully relied on the Reynolds defense. The victory was short-lived. The claimant, a detective sergeant with the Metropolitan Police, was alleged to have been paid for information about extradition requests concerning Russian oligarchs. Investigative journalists believed that a police investigation into the claimant may not have been conducted properly, and approached the claimant for comment. An article was published in the Times concerning a subsequent police investigation, prompted by the journalists' inquiries. The newspaper raised defenses of Reynolds and justification. On the Reynolds defense, the Court of Appeal found that, following Jamil v. Wall Street Journal 2006 UKHL 44, 2007 1 AC 359, there are now three requirements for a Reynolds defense to be mounted: a. The article as a whole must be on a matter of public interest; b. The inclusion of the defamatory allegations should be part of the story and make a real contribution to it; and c. The steps taken to gather and publish the information must be responsible and fair. The Court of Appeal concluded that the inclusion of the claimant's name in the story was not warranted, and the steps taken to investigate the story were not to be classed as responsible or fair journalism. The Master of the Rolls observed that it would rarely be justifiable reportage to report that an unidentified informant had provided information which, if true, may incriminate a claimant. He concluded, at 63, that it would be tipping the scales too far in favor of the media to hold that not only the name of the claimant, but the details of the allegations against him, can normally be published as part of a story free of any right in the claimant to sue for defamation just because the general subject matter of the story is in the public interest. The Master of the Rolls was satisfied that the steps taken to verify the information were such that the journalists did not seem to have done much to satisfy themselves that the allegations were true. They were unsubstantiated, unchecked accusations, from an unknown source, coupled with speculation. The Court of Appeal registered its distaste with a claim to Reynolds privilege in relation to allegations which were the subject of an investigation. The Master of the Rolls commented, at 104, in my view, responsible journalism requires a recognition of the importance of ensuring that persons against whom serious allegations of crime or professional misconduct are made are not forced to respond to them before an investigation has been properly carried out and charges have been made. It is very easy for allegations of impropriety or criminal conduct, page 111, to be made, to the police, professional bodies, and others who may have a duty to investigate their truth, out of malice, an excess of zeal or simple misunderstanding. If the details of such allegations are made public, they are capable of causing a great deal of harm to the individual concerned, since many people are inclined to assume that there is no smoke without fire. Moreover, there is a serious risk that once the allegations have been published, the person against whom they are made will feel obliged to respond to them publicly, thereby depriving himself of the safeguard of the ordinary process and risking a measure of trial by press. The Master of the Rolls concluded by drawing a distinction between the present case, in which the allegations were published in detail in the article, with the claimant being identified and claims made about his conduct giving rise to the investigation, and the publication of the simple fact that a complaint has been made against him, without any details being given, or publication of the mere fact that a person has been charged with a criminal offense. The court also concluded that it was not for editors to determine whether the inclusion of the defamatory allegations was in the public interest. What was for editorial judgment was the tone or the manner in which the story sought to attract the attention and interest of readers. Whether or not the allegations were in the public interest was a question for the court. Considering the defense as a preliminary issue. 22 to 137. In GKR Karate v Yorkshire Post 691, the claimants sued the defendant newspaper for libel in an article in which it was suggested that the claimants were selling karate classes taught by unqualified instructors for large sums of money. In pleading qualified privilege, the defendants asserted that the public had a right to know about unscrupulous practices of the sort which they alleged, and that it was therefore in line with Reynolds to raise the defense in respect of the articles as a preliminary issue. Popplewell J. decided that the questions of qualified privilege and malice could be heard as preliminary issues despite the claimant's objection that without a full hearing the test of qualified privilege laid down in Reynolds could not be properly applied, nor could the question of malice be properly examined. The judge went on to apply Lord Nichols' 10 criteria from Reynolds to the facts of the case, and upheld the defense of qualified privilege. He regarded the importance of this information to readers and the apparent reliability of a witness who was the spokesman for the governing body, and who was the source of the allegations, to be primary considerations. However, he stressed that his decision was based on the particular facts of the case, and that as the facts of each case vary immensely, a decision in one case may not have any bearing on a decision in another case. The decision was upheld by the Court of Appeal, which considered, in the words of May L.J., that to decide the question of qualified privilege as a preliminary issue was fair, sensible, and economic. Responsible journalism. 22 to 138. In Lauchinsky v. Times Newspapers Ltd., the claimant, a Russian businessman, sued the defendants for libeling him in reports, stating that he had been engaged in international criminal activities. The defendants raised the defense of qualified privilege on the grounds that the allegations were so serious that the public were entitled to know about them. In Lauchinsky v. Times Newspapers 692, they sought to amend their defense to include facts of which they had not been aware at the time of publication, but which supported their contention that the public should be informed of the complaints. Page 112. Court of Appeal dismissed their appeal, stating that defendants could only rely for purposes of qualified privilege on matters of which they knew at the time of publication, and they could not go trawling for relevant matters afterwards. The right to freedom of expression would not be unduly restricted if the defendants were prevented from raising facts found at a later stage after the articles had been published. In Lauchinsky v. Times Newspapers, No. 2, 693, the Court of Appeal considered the question of the liability of newspapers in the light of Reynolds, and held that where there was the necessary duty in the press and a corresponding legitimate public interest in being informed of the material in question, then, subject to the Reynolds tests, the defense of qualified privilege will apply. This would be subject only to the requirement that the defendants must have fulfilled the test of responsible journalism. Such a standard should not be set too high or too low. Lord Phillips said, once Reynolds privilege is recognized, as it should be, as a different jurisprudential creature from the traditional form of privilege from which it sprang, the particular nature of the interest and duty which underlie it can more easily be understood. He accepted that a responsible journalist might equally decide to publish or not to publish an item, and disapproved the test of whether to publish suggested by Gray J. in the court below, namely that publication would be in accordance with a duty to publish if the journalist would be open to criticism if he did not publish it. 694 In the Jamaican case of Bonnick v. Morris 695, the issue was whether a newspaper report, published by the defendants, was covered by qualified privilege. The Privy Council held that in considering Reynolds' qualified privilege, the law should apply a flexible meaning to the standard of responsible journalism. In this context, if the words used were ambiguous, though they might readily convey a certain meaning to a reasonable ordinary reader, they need not be read exclusively in that one sense. In considering whether the defendant journalist had acted responsibly, he should not be unduly penalized. It was a matter of degree whether he could invoke qualified privilege. 22 to 139. In Jamil v. Wall Street Journal, Europe, 696, the defendants published a report under the heading "Saudi officials monitor certain bank accounts," and also stating the focus is on those with potential terrorist ties. There were also reports that the authorities in the USA were interested in several Saudi nationals. The claimants sued and the jury found that the statements were defamatory of them. The defendants pleaded qualified privilege on the ground that this was clearly within the ambit of Reynolds Privilege. The defense failed at first instance and before the Court of Appeal, but was upheld in the House of Lords. Lord Bingham, with whom Lord Hope agreed, considered the ground on which the judge and the Court of Appeal had rejected the Reynolds defense, namely the failure of the newspaper to allow sufficient time prior to publication for the respondents to comment on the allegations, to be too narrow, with the effect that the liberalising effect that was the intention of the Reynolds decision had been subverted. He considered the article in issue to be the sort of neutral investigative journalism which the Reynolds defense existed to protect. Lord Hoffman revisited the speech of Lord Nichols in Reynolds and sought to clarify what was meant by Reynolds privilege. He said the use of privilege, although historically accurate, may now be misleading. It is the material being published which is privileged, not the occasion on which it is published. He suggested it might more accurately be called the Reynolds public interest defense rather than privilege. He went on to deliver a rejoinder to judicial criticisms of the Reynolds concept of responsible journalism, which had been described by EDJ as too vague and subjective. Upholding the test, he said that it was an objective test and no more vague than standards such as reasonable care used in other branches of the law. He reiterated that the Reynolds standard of responsible journalism needed to be applied in a practical and flexible manner, and commented that the case before the House suggested that Reynolds had had little impact on the way the law was being applied at first instance. Lord Scott discussed the principles underlying Reynolds by reference to the general common law of qualified privilege. He did not consider that the defense, page 113, was a different jurisprudential creature from traditional qualified privilege. Nevertheless, he agreed that the lower courts in this case had not correctly applied the principles coming out of Reynolds. The fundamental reason for allowing the appeal was that this was a story with very high public interest indeed. He considered there to be no difference of principle between the law lords on the appeal, but stated that if there was, he agreed with the reasons given by Lord Hoffman. Baroness Hale commented that it was not helpful to analyze the particular case in terms of a specific duty and right to know. That had led to the narrow and rigid approach in the courts below. She pointed out that the defense did not create a free-for-all to publish without being damned. There was only a public right to know if, 1, there was a real public interest in conveying and receiving the information, and, 2, the publisher had taken the care of a responsible publisher to verify the information published. She agreed with Lord Hoffman for the reasons he had given that the newspaper in this case had passed the test. Lord Hoffman acknowledged that there is no question of the privilege being defeated on proof of malice, since the propriety of the conduct of the defendant was built into the conditions under which material is privileged. He then broke down the Reynolds defense into 3 core issues, as follows. A. Public interest. The first question was to ask whether the article as a whole, rather than the defamatory statement in isolation, was in the public interest. Whether it was justifiable to include the particular defamatory statement complained of was a separate question. Whether or not the article was in the public interest was not a question which newspapers could be left to decide, since they were not often the best judges of where the line must be drawn. In this case, the publication easily passed the test. The thrust of the article as a whole was to inform the public that the Saudis were cooperating with the U.S. Treasury in monitoring bank accounts. It was a serious contribution in a measured tone to a subject of very considerable public importance. Lord Hoffman also recommended that there was no need to analyze this question each time in the classic sense of asking whether there was a duty to impart the information and an interest in receiving it. In Reynolds it had been accepted that in public interest cases there is a professional duty on the part of journalists to impart the information and an interest in receiving it. This could be regarded as a proposition of law and not decided each time as a question of fact. b. Inclusion of the defamatory statement. Lord Hoffman went on to consider whether it was necessary for the article complained of to name the claimants specifically as among those whose accounts were being monitored. He commented that the fact that the article as a whole was in the public interest did not allow a newspaper to introduce damaging allegations which served no public purpose. Such allegations needed to be part of the story. The more serious the allegation, the more important that it made a real contribution to the public interest element in the article. Lord Hoffman was nevertheless prepared to make more allowance for subjective editorial judgment on this issue than on the question of public interest as a whole. He concluded that in this case, the inclusion of the names of large and respectable Saudi businesses was an important part of the story. It showed the Saudi cooperation to be genuine and extensive, encompassing companies within the heartland of the Saudi business world. In conveying that message, it was necessary to include names. c. Responsible journalism. Lord Hoffman then considered the steps taken to gather and publish the information under the generic category of responsible journalism. He considered the question to be whether the defendant had behaved fairly and responsibly in gathering and publishing the information. On the question of verification, Lord Hoffman reaffirmed Lord Nichols' page 114 recommendation that issues of primary fact, such as whether or not the court accepted the defendant's account of his attempts to verify the allegations he intended to publish, should be left to the jury. Lord Hoffman paid particular attention to efforts made by the defendants to verify with the U.S. Treasury that the claimants' names were on a list of individuals and companies being monitored. He concluded that there was unchallenged evidence from a confidential source that the U.S. Treasury had confirmed the accuracy of the story. Lord Hoffman went on to consider what opportunity had been afforded to the claimant to comment on the allegations prior to publication. He pointed out that Lord Nichols had not suggested that failure to report the claimant's explanation would always be fatal to the defense. He considered the stance adopted by the judge and the Court of Appeal on this issue to be unrealistic. The story had been confirmed by the U.S. Treasury. Whilst Lord Nichols had said in Reynolds that the importance of approaching the claimant was that he might have information others did not or would not have disclosed, that was not the case here. The claimant in this case would have had no knowledge of whether there was covered surveillance of his bank account. He could only say he knew of no reason why there should be. While Lord Hoffman accepted that it might have been better had the defendants delayed publication to give him time to comment, the failure did not deprive them of the defense. Verification and sources. 22 to 140. James Gilbert Ltd. and Webb v. MGN Ltd. 697. The claimants were manufacturers of sporting goods including rugby balls used in the 1999 Rugby World Cup. On October 3, 1999, the Sunday Mirror alleged that unbeknown to the claimants, their subcontractor in India, a Mr. Verma, was employing child labor in appalling conditions. The article reported that the claimant's managing director, Mr. Webb, would mount a thorough investigation into the allegation. On October 8, the claimant's solicitors wrote to the newspaper's lawyer requesting that any further inquiries of their clients should be directed to them. The following Sunday, October 10, the newspaper published a further article which reported Mr. Webb's promise to send investigators to India the following day. On October 13, the claimant's solicitors again wrote to the newspaper's lawyer, stating that their clients had initiated an inquiry and requesting that the newspaper supply its evidence of child labor in order for the inquiry to be thorough. On the same day, a reporter was instructed to contact Mr. Verma. He was unable to speak to Mr. Verma until Saturday morning, October 16. The reporter asked Mr. Verma whether the claimants had sent anyone to India, in accordance with their promise. Mr. Varma stated that nobody had been sent and he had not been contacted. Following that conversation, another reporter telephoned Mr. Webb at home on Saturday lunchtime to confront him with Mr. Varma's allegations. Having instructed solicitors to deal with the matter, Mr. Webb refused to speak to the reporter. The reporter also left a message on Mr. Webb's answer phone, stating that he wanted to talk to Mr. Webb about an article to be published in the following day's issue. No attempt was made by the newspaper to contact the claimant's solicitors. The following day the article complained of was published with the headline, "Slave Ball's Firm Breaks Its Promise." As the headline suggested, the article alleged that the claimants had reneged on their promise to send investigators to India. In fact, the newspaper had been given false information by Mr. Varma. The claimants had honored their promise and had sent 2 senior employees to India on October 10 to mount a thorough investigation of the allegations of child labor, which the investigation showed to be false. The claimants sued for libel. The newspaper ran a qualified privilege defense based on Reynolds. The claimants sought summary disposal under S.8 of the Defamation Act 1996. Both sides accepted that the question of whether the claimants had sent anyone to India was a matter which was, in principle, easy to verify. The claimants contended that they had put in place a proper channel of communication. Page 115. Between them and the newspaper, via their solicitors. In the circumstances, it was reasonable for Mr. Webb to refuse to speak to the reporter. The judge approached the matter by applying Lord Nichols' 10 criteria. He regarded the allegation of breach of promise as serious, made worse by the inference that the claimants were cavalier about the issue of child labor. While accepting that the original allegation of child labor was of public interest, he felt that the question of whether the claimants were investigating the matter to be of far less public interest. He regarded Mr. Varma as a less than reliable source, in isolation, bearing in mind that it was he who the newspaper had accused of employing child labor. More fundamentally, he regarded the newspaper's attempts to verify the information as wholly inadequate, even without the benefit of hindsight. It was reasonable and sensible for the claimants to have instructed their solicitors to deal with media inquiries. It would have been very easy for the newspaper to have made inquiry of the solicitors at any time during the week before publication. Any urgency on the part of the newspaper was self-made as a result of their failure to address the matter earlier and by the fact that the newspaper came out on a Sunday. As he observed, the newspaper may have had an interest in running the article on that particular Sunday, but any public interest in publication would not have been damaged by the article being delayed until the newspaper had spoken to the solicitors or Mr. Webb. Finally, he observed that the newspaper had presented what it had been told by Mr. Varma as a fact rather than an allegation. In the circumstances, he had no difficulty in holding that the duty and interest tests had not been satisfied. 698. Public interest. 22 to 141. In Al-Fajr vh Saudi Research and Marketing 699, the defendant newspaper published an account of allegations which had been made about the claimant in the course of a political dispute in the expatriate Saudi community. At first instance, Smith J. held that the allegations could not be covered by qualified privilege, but the Court of Appeal overruled that decision. They concluded that the political dispute was being conducted in the public arena and was thus in the public interest to know what allegations were being made by one side or the other. Provided the defendant did not adopt the allegations as true, the defense of qualified privilege ought to be available. In Lukoyak v. Unidad editorial essay 700, the claimant, who served in the Falklands for Britain, complained of the allegation as published in El Mundo that he was a self-confessed war criminal who had shot an Argentinian soldier after he had surrendered. He sought to strike out a defense of qualified privilege on the basis that it had no realistic prospect of success. The judge refused the application, concluding that the article was in the public interest. The judge also ruled out from the protection of qualification the copy of the article that remained on the defendant's website after the complaint had been received. As above, the Court of Appeal has ruled out this test as imposing too stringent a standard. Claimant's opportunity to respond. 22 to 142. In Galloway v. Telegraph Group Ltd 701, the Daily Telegraph published articles alleging that the claimant, a member of parliament, was in the pay of the Saddam Hussein regime and that he had received at least £375,000 from the regime. It also alleged that the claimant had been using a charitable appeal that he had founded the Merriam Appeal as a front for such activities. The background to the articles was that after the American invasion of Iraq had commenced, a Daily Telegraph journalist attended the offices of the Iraqi Foreign Ministry in Baghdad, where he came across documents which appeared to suggest that the claimant was in the pay of the Saddam regime. The documents were translated and sent back to London, and on April 21, 2004 the defendant contacted the page 116. Claimant seeking his explanation. On April 22 and 23 articles about the documents were published in the newspaper. One of the central issues in the case was whether or not documents found by the defendant's journalist in Iraq were adequately put to the claimant in advance of publication. The claimant contended that it was never put to him that he was in Saddam's pay or that he had received at least £375,000 from the regime. He said that he had no opportunity to see the documents and they were not read to him. The newspaper merely provided him with a summary of the allegations and obtained his comment in light of that summary. What was put to him was that the Merriam Appeal was receiving monies from the Iraqi regime, an allegation he in any event denied. He claimed not to have been told how the documents had been found, or the newspaper's belief that they were genuine. Nor was he told that the newspaper intended to publish a story the following day. The judge rejected the defense of qualified privilege. The Court of Appeal affirmed the judge's decision and took into consideration the case law of the European Court of Human Rights, which stressed the importance of the national court striking a fair balance between the protection of freedom of expression enshrined in Art. 10 and the protection of a person's reputation enshrined in Art. 8 as an aspect of private life. How the balance was struck was a matter for the judge, and the court would not interfere with his decision. 22 to 143. In Armstrong v. Times Newspapers Ltd 702, the Sunday Times published an article accusing the claimant, a champion tour cyclist, of taking performance-enhancing drugs. The article repeated allegations which were to be published in France in a book written by a co-defendant in these proceedings. The claimant applied to strike out the defense of Reynolds' qualified privilege. The judge was invited to rule that even assuming all the facts in the defendant's favor, the defense of qualified privilege under Reynolds had no prospect of succeeding. The judge struck out the defense. The defendants had taken no steps to verify the allegations, there was no urgency to publication, and the claimant was not contacted to comment on the substance of the article. The article did not publish the gist of what the claimant might have said in response to the various claims made, and was sensationalist in tone. For all those reasons, he struck out the defense. On appeal, the judge's decision was overturned. The Court of Appeal ruled that on a summary judgment application, a judge had to be careful to ensure that he accepted the defendant's case as true unless there was no reasonable prospect that some or all of it would be accepted as true at trial. It was wrong on the facts of the case to deny the defendant newspaper the benefit of the trial process, and the judge had erred in making findings of fact at the hearing without having heard all the evidence. In particular, the detailed history of the article was a matter for witness statements and disclosure, not for summary disposal. A failure to put allegations to a claimant was not necessarily determinative of the defense of qualified privilege, and the defense would be restored. This approach is in line with the thinking of the House of Lords in Jamil v. Wall Street Journal, see para. 22-139. The case subsequently settled. Responsible journalism and book publishing. 22 to 144. In Charman v. Orion Publishing Group Ltd 703, the Court of Appeal, applying Jamil, overturned the first instance judge's decision on qualified privilege. The claimant police officer brought proceedings against an author and publishers of a book entitled Bent Coppers. The book made allegations of corruption in the police force. The court held that the defense of privilege based on responsible journalism applied equally to books. However, because authors and publishers were not under the same pressure of time before going to press, greater care would be expected of them in demonstrating that they had acted responsibly. The judge had erred in focusing on the passages complained of rather than the book as a whole in determining whether the author had taken proper care. The book, on the whole, page 117, was carefully researched and sourced, and the judge had not afforded sufficient weight to that. He had also failed to take sufficiently into account the care with which the author had exercised his editorial judgment. Ward L.J. commented. Jamil emphasizes how important it is that weight be given to the professional judgment of the journalist. Where opinions may reasonably differ over the details which are needed to convey the general message, then deference has to be paid to the editorial decisions of the author, journalist, or editor. True, it may be that the journalist has to subject the material, as the judge held, to critical analysis. But it is his assessment of that evaluation which is important, not the judge's own evaluation of the material conducted with the benefit of hindsight and with the sharp eye of a trained lawyer. 704. 672 2001 2 AC 127. 6.